My name is Brian Mayer. I'm an attorney practicing family law throughout Southern California. And the question that I'm answering today is, when are medical records admissible or discoverable in family law cases? Now, when we talk about medical records, we're talking about all records related the uh, to the medical, psychiatric well-being of the individual involved. So doctors, dentists, therapists, psychologists, anyone who basically uh, for whom you can have any sort of health related insurance involved. That's what I'm talking about when I'm talking about medical records. And we have to break the individuals up into three categories, and that will tell us what our rights are in our family law cases. Now, first, when we're talking about individuals who are not children to the action, who are not parties to the action, uh, the medical records of third parties are not discoverable under most any circumstance. And this sometimes comes up. Let's say the mother in the case has a new boyfriend, and dad suspects he's a druggie and wants some of his medical history, or believes that um, he has a psychiatric condition that is manifesting in a harmful way around the children, and he wants to get to the boyfriend's medical information to try to find out what's going on and present that to the court. And that information is generally not discoverable, meaning you can send out a subpoena, you can ask the question of the boyfriend, pull him in for a deposition, and that information is not discoverable. Um, and it's not discoverable, first of all, uh, it may or may not be relevant, but generally the objection that can be raised is that it violates the physician patient or the therapist patient privilege. That's a privilege that everyone has. That's generally speaking, when we talk to our doctors, we talk to our mental health professionals, even when we talk to our dentists, the information that's exchanged and the work that they do is information that is generally not discoverable in any sort of court setting. Okay, and we'll talk about that more a little bit later. The second group is when we're talking about parents, okay, and the discovery of the health records of other parents. And there may be various reasons for getting at that. It may be that mom had to leave her leave their child behind for a while, and it's suspected that mom has an alcohol problem, and the reason she left is because she has this alcohol problem, and dad wants to bring that to light. Generally speaking, even with parents, the physician patient privilege or the therapist patient privilege still generally prevents the discovery of those records. But there is a major exception that tends to arise. And where it tends to arise is in when the where it tends to arise is when the the person who has the privilege uses their medical condition as a sort of excuse or explanation elsewhere in the case. And so let's say, for example, let's say that mom doesn't work. Okay, she's a stay-at-home parent, and dad wants her to go out and work, or at least have income imputed to her, so that his child support obligation is lowered and he's not paying so much, because he wants, understandably, wants mom to work and chip in and contribute toward the financial needs of the child. But so mom says, "Hey, this, I have something wrong with my back. I am unable to work medically. It is not a possibility. So do not impute income to me. Do not order me to seek work. Help me out." And in that situation, at that point, mom has waived her privilege, because mom has made her health condition an issue of the case. And so now dad has a right to get those documents. There are various ways to request them. He can subpoena them directly from the healthcare provider. He can make a request for a demand of production of the documents directly from mom. But regardless, mom has waived her privilege because she opened the door. Okay, so that is the big exception when we're talking about parents or spouses wanting to access the medical records of one another. And then last of all, in terms of discoverability, there's also the medical records of the child. And this is where, on this one, this is where it starts to get very, very dicey because it depends uh, very much on how any custody order is worded and also in what state you're located. So the answer is going to vary from state to state and oftentimes from case to case. So I can say generally, if there's no custody order in place, then uh, then either parent has access to the medical or health records of their child. If a custody order is in place, then again, it depends very much on the state, but if there's a joint legal custody situation, that is, both parents are allowed to be involved in the medical decision making of the children, then both parents are also allowed to access the health information of their minor child, and they have that access because how can you make an informed health decision for your child if you can't even access their records? So in a sort of joint situation, they have that access. When either parent has sole or full legal custodial rights, that is they have the sole right to make the decision about medical related or health related decisions for their child, that parents can access the health records undoubtedly. But where the big question mark comes is really when you have a parent who does not have legal custody, any legal custody, and who nonetheless, by court order, and who nonetheless wants to access their child's medical information. And in those situations, it's really going to be very much dependent on how the court's order is worded and also in which state that you're located. And that's something where you really would need to have an attorney look at the specifics of your information to really determine what in your specific case is the case. I can tell you that even in those cases where um, even in those cases where the parent does not have legal custodial access to get to their minor child's health information, that's something that generally speaking they can ask for directly from the other parents through a formal request for production, or if need be, they can go to the court and order that and request an order for that information to be specifically released to them. So even when they may not have the right to ask for it and get it outright, they can usually, the circumstances are such usually that they can just get the information anyway. There just may be an extra step or two. But again, when it comes to the child, it becomes very situation specific. Um, so in talking about these things, we've talked just now about the discoverability about these items, but let's talk about the admissibility of these items. Okay, that is the ability to take the information and put it before the court and have the court consider it. Well, the first thing that you have to understand is that oftentimes you really have to think about whether or not the information is in fact relevant to what's going on. So a diagnosis, for example, diagnosis itself does not necessarily impact uh, a person's ability to perform any given function. And something that I see really commonly in a family law situation is when you have one parent who has a psychiatric diagnosis, like a parent has bipolar disorder or is diagnosably a narcissist or has some sort of diagnosable psychiatric condition that makes them a less than perfect person. And so there's just a natural instinct, hey, let's get this in front of the court. But the fact is that the diagnosis itself doesn't necessarily have any impact on the case, or I'm using the example of parents, does not necessarily impact the person's ability to be a good parent. So, for example, if you have someone who has a bipolar disorder diagnosis, they're properly medicated, the medication properly controls the diagnosis, The fact that they're diagnosed bipolar is basically irrelevant, because what is relevant is how they act, and particularly how they act around the child. And if they have the diagnosis and the condition under control, then the diagnosis itself is basically irrelevant. So, so that's the first thing you have to consider. But generally speaking, then, if you have the information, regardless of whether or not it is ordinarily protected by the physician patient privilege or the therapist patient privilege, regardless of whether or not it's protected, that privilege has to do with the discovery of it, not so much the admissibility of it. So if, let's say, mom says, "Hey, I can't work and my back is broken," and um, uh, uh, she, it's relevant to the case, uh, but dad has not gone through the formal process, he can still introduce any documents that he has in his possession. Uh, let's say the dad is a drug abusing alcoholic, and he's been in and out of rehab, and he relapses all the time, and he has admitted this to his counselors, and he basically just can't keep clean. And so dad has not made his addiction an issue in the case, so mom can't get the information through the normal discovery process. But let's say that somebody drops an envelope off on mom's doorstep, and she looks inside, and lo and behold, it's dad's medical information, and it shows all of this information to be true. Well, it's not protected by, at this point, it's not protected by the physician patient privilege, because that just pertains to discovery. But the problem that mom is going to have, if she has those documents, is laying the proper foundation to get it admitted, because the documents have to be authenticated. So if mom just said, "Hey, here are some medical documents," and they show dad's an alcoholic, and dad says, "I object, there's a lack of foundation," and mom says, "Well, I found them on my doorstep, so I assume that these are the real documents," the judge would say the objection is sustained and it can't be admitted. But if mom took those same documents, gave them to, put them in front of dad and said, "Do you recognize these documents? Do these?" And dad says, "Yes." And she says, "What are they?" And he says, "These are my medical records from when I've been in and out of rehab." And mom says, "These appear to be fair and accurate copies of those records." And dad says, "Yeah, I know what they look like. They are." Mom can then move the records into evidence, because the foundation has been laid by dad, who is familiar with them and can authenticate them as being genuine. So, um, and same sort of thing with a third party or the child. If you get the records, um, the admission into evidence is not prohibited by any sort of privilege, a patient physician privilege or a therapist patient privilege, but there may be other issues as they relate to laying a foundation to authenticate those documents. So, so I hope that this was of some assistance. Thank you so much for watching. Again, my name is Brian Mayer. I'm a family law attorney practicing throughout Southern California, and I wish you the best, and take care.